Hi everyone, I'm Jay, the Principal Migration Lawyer at Flow Migration Law, and welcome back to the channel. The usual journey for an Australian partner visa is a two-step process. First, you apply for a temporary visa, and then about 2 years later, you apply for the permanent one. But what if you could skip that second step? It's called a double grant, and it's where both the temporary and permanent partner visas are granted at the same time. This is possible for couples in what the law calls a long-term relationship. But how does the department assess these? And crucially, can you qualify if you haven't physically lived together for the entire required period? Today, we're looking at a real case study that answers these very questions. So let me introduce you to the clients at the heart of this story. The sponsor, an Australian citizen, and the applicant, an Indonesian citizen. They had been together for 4 years and married for 2. Their story began when the sponsor was traveling in Indonesia. They formed a genuine connection, which quickly grew into a committed relationship built on daily video calls and messages. After about a year, they knew they wanted to build a future together. Over the next few years, the sponsor made many lengthy visits to Indonesia. They started making shared plans, he provided financial and emotional support, and they introduced each other to their families and friends. However, significant work commitments in their respective countries plus visa limitations meant they had to continue their relationship long distance. While they were completely committed, the practicalities of their situation kept them physically apart for long stretches. Approaching the 4-year mark of their relationship, they were finally ready to apply for the onshore partner visa here in Australia. Now, there was no doubt their relationship was strong and genuine. The evidence was all there. The critical question was whether they could meet the strict legal definition of a long-term relationship in order to get the double grant. Under the law, a long-term relationship is generally one that had continued for at least 3 years or 2 years if you have a child together. Our clients had been married for 2 years, but together for 4. The challenge was that first year before they were married. Could the time they spent in a committed but long-distance relationship count towards the 3-year requirement? The main issue is that the law often understands a de facto relationship as one where a couple is living together. As they had never lived together continuously, this could have been a major roadblock for their application. This is where understanding the legal subtleties becomes so important. Our consultation process involved a deep dive into their entire relationship history. We listened to their whole story, looking beyond just dates on a calendar. It was discovered that even with the distance, their lives were deeply intertwined, long before they were married. Our argument hinged on establishing that they were already in a de facto relationship for 1 year before their 2-year marriage began. We contended that from their 2nd year together, their relationship already met the de facto criteria. They had declared the commitment. The sponsor was providing support. They were known as a couple by everyone in their lives. They were making serious life plans. We argue that their periods of living apart were temporary and involuntary, caused by external factors like work and visa rules, not by a lack of commitment. We then meticulously guarded the evidence to support this narrative. The goal was to show that the marriage was simply the formalization of a deep commitment that already existed. This allowed us to argue that they met the 3-year mark, and they instructed us to proceed with this detailed submission. The result? The Department of Home Affairs accepted our submissions. Our clients received a double grant. Their temporary subclass 820 visa and their permanent subclass 801 were granted at the same time. They were absolutely thrilled. They could finally move forward with their life in Australia. This case highlights a few really important points for anyone applying for a partner visa. First, your entire relationship history matters. Don't discount the time you spent together before you were married or living together. A committed long-distance relationship can be recognized if the evidence tells the right story. Second, the concept of living together is not always black and white in migration law. The law does allow for circumstances where couples live apart temporarily, but you need to prove with detailed explanations. And third, a well-prepared application tells a story. It weaves your documents into a compelling narrative that directly addresses the legal criteria. Navigating the subtleties of what the law considers a de facto or long-term relationship requires a deep understanding of the legislation and policy. With over 80 years of dedicated experience in Australian migration law, as the principal lawyer here at Flow Migration Law, I've helped many couples translate their unique relationship stories into successful visa applications. If your situation has complex elements like periods of living apart, presenting your case in the best possible light is important. To discuss your specific circumstances, I invite you to book a consultation by emailing me directly at js@flowmigrationlaw.com.au. Thanks for watching today. If this video was helpful, please give this video a thumbs up and subscribe for more. We'll see you next time.